Thank you all for joining me for the companion presentation on the 14 prohibited personnel practices. So we have one presentation that focuses on retaliation for making protected disclosures and retaliation for engaging protected activity. And today's presentation is going to focus on all of the other PPPs covering discrimination, hiring offenses, and the category that we call potpourri. My name is Ashley Tees. I serve as the Deputy Chief for the Diversity Outreach and Training Unit at the U.S. Office of Special Counsel. So thank you all for joining. So let's go to the next slide. So I like to begin all of the presentations that I provide on the key concepts. I always remind folks, if you remember anything about this presentation, remember this slide. Specifically, it talks about the merit system principles. Those are your dues within the federal government. They're the 9 aspirational goals for how the federal workforce should be managed. When thinking about not retaliating against employees, not discriminating against employees, making sure that you respect employees' constitutional rights and treat them fair and equitably. And we'll talk about the merit system principles a little while later when we talk about hiring offenses as well. So you have these dues. Those are the merit system principles. On the flip side, you have the 14 prohibited personnel practices, and those are the do nots within the federal government. So to say if you remember anything, remember the dues are those merit system principles, and those 14 prohibited personnel practices, those employment activities that are banned within the federal government, are your do nots, those 14 PPPs. So let's go ahead and move to the next slide. So this slide breaks down the 14 prohibitions. So the first category is discrimination. Then you have hiring offenses, you have retaliation, and then potpourri. And as I explained in the first part of this video, you can enjoy watching the retaliation videos in a video that is provided by my chief of our Diversity Outreach and Training Unit, Shireen Mawazed. So today we're just going to focus on discrimination, hiring offenses, and potpourri. Next slide, please. So our first category is discrimination. And we'll move to our next slide. And this talks about the discrimination PPP. So there are 2 different prohibitions that fall under this umbrella category of discrimination. First, you have B1. And B1 bars discrimination based on race, color, nationality, religion, sex, handicapping, condition, age, marital status, and political affiliation. Well, the types of discrimination that are not bolded and italicized are your typical types of Title VII discrimination. And by regulation, our office generally does not review those allegations. Rather, we let folks know that they can file with their agency's EEO office. And there are 2 points in the process where we'll notify folks. When a complaint initially comes in, it goes to our case review division. If the filer, and it can be a former employee, a current employee, a probationary employee, an applicant for employment, so those are the complainants. If a complainant is alleging purely EEO, we will let the filer know that they can file with their agency's EEO office and close out the complaint. But say that the individual is alleging retaliation, but they also believe that the actions taken were due to discrimination. So once the complaint is moved to one of the attorneys or investigators in our investigation or prosecution division, we then will let the individual know that we will look at the retaliation aspect of it, but their EEO claim, they can file with their agency's EEO office. So as it relates to marital status and political affiliation discrimination, we do review those allegations. So what exactly is marital status discrimination? Well, it's pretty much as it sounds. Are you being treated differently based on your marital status, based on you being married, single, divorced, widowed? One of my colleagues handled a case concerning marital status discrimination where a gentleman alleged that he was denied a promotional opportunity based on him being single. He stated that he had applied for an opportunity at his agency, and during the interview process, the interviewer asked him what his plans were as it related to his long-term girlfriend. Said he hadn't made a decision at that point in time. They were just seeing where things were going. They didn't plan on getting married at that point in time. Well, the gentleman was denied that promotional opportunity, and he said he noticed that the person who was selected was married. Also, several other folks who had been promoted at the agency were also married. So he filed a complaint with our office because he wondered if, given that question and the practice of promoting married employees, if there was some sort of discrimination against him during that hiring process. And through our investigation, the interviewer did admit to the fact that he did not select that gentleman because he was single and he wanted to promote married employees. Married employees were viewed as being stable because they had families to support, they had a spouse to support, so they'd be more committed to the agency and stay for the long haul compared to someone who was single and could break up with their significant other and move on. So that is why that gentleman was denied the promotional opportunity based on his marital status, him being single. With political affiliation discrimination, it is also pretty straightforward as well. Is there evidence that someone is being treated differently based on their partisan political affiliation? And we're talking about partisan. What exactly does that mean? Well, according to the courts, it means showing a particular allegiance to, say, a particular candidate. Thinking about someone running for a presidential election, maybe it's someone running a candidate in a local election, someone running for Senate, even a political action committee. So is there evidence to demonstrate that someone is being treated differently based on their partisan political affiliation? As you can see on the screen, at this point in time, political issues or issues that are closely identified or particularly aligned with a particular party are not contemplated under the statute. So let's now move to the next prohibition. So we talked about B1. Now we're going to talk about B10. And this is a second prohibition under discrimination. So B10 bars discrimination based on conduct. It could be on duty, off duty, that does not adversely impact someone's ability to perform, whether the employee's ability to perform the duties or the performance of others. So think about someone who is a volunteer firefighter on the weekend, and their manager finds out that they're a volunteer firefighter. Maybe they don't care for firefighters, so they decide to reassign that employee to another shift. And they're doing this based on that employee's outside activity of being a volunteer firefighter. So there's evidence to demonstrate that that individual serving as a volunteer firefighter has no impact on their ability to perform their duties or on the ability of others to perform their duties. So that would be a violation of B10, reassigning that employee based on that outside activity, or based on that conduct, rather, I should say, that has no adverse impact on the employee's ability to perform or on the performance of others. Although, as you can see, agencies can take action if they can demonstrate nexus. So if there's a nexus between that conduct and the efficiency of the service. For example, there was a board case last year concerning a gentleman at a federal agency who was observed putting extra food in his to-go container at the agency cafeteria and not paying for that food. So apparently what happened is that he'd gone through the line, filled up his container, paid, and then he went back and added more food. Well, a cafeteria worker observed him. Also, agency video cameras observed him as well. So the agency decided to remove him from federal service, and he filed an appeal with the Merit Systems Protection Board. And while the removal was not upheld, given the Douglas factors analysis, the board did conclude that the agency could discipline him. The reason being is because the agency could demonstrate a nexus between his conduct and the efficiency of the service. Specifically, the board concluded that his actions would cause the agency to lose trust and confidence in him, given that he was engaging in theft. He was committing theft against the agency. Also, as part of it, one of his collateral duties concerned preventing theft. So there was that nexus there, and the agency could proceed with disciplining that gentleman. So let's go ahead and move to our next category. So our next category is hiring offenses. And the hiring offenses really tie back to the merit system principles and the idea of fair and open competition and making sure that folks are promoted or hired into positions based on their merit. So let's move to the next slide. So the first PPP that we're going to talk about under hiring offenses is B2. I often refer to this one as a PPP relic, primarily because we do not see many of these allegations. So just to kind of give you a quick example of what constitutes a B2. So say I'm a hiring manager and I'm looking to hire an accountant. Bill applies for the accountant position. And as part of his application package, he includes a recommendation letter from his senator, Senator Jackson. Well, Senator Jackson has no familiarity with Bill, rather Bill is just a constituent. If I, as a hiring manager, rely upon that recommendation letter when making my hiring decision, I've committed a B2 violation. And the reason it's a violation is because there's that lack of personal knowledge. That's what makes it an improper job reference, that lack of personal knowledge. Now, say instead Bill had provided this recommendation letter and Senator Jackson could actually attest to Bill's abilities to serve in that position, to serve as an accountant. Could attest to the fact that Bill had the skill set necessary to serve as an accountant. There was that personal knowledge there. If the personal knowledge was there, then it would not be a violation of B2. But as I was saying earlier, we rarely see these complaints, primarily because the practice of providing form recommendation letters for constituents has been done away with. So let's go ahead and move to the next prohibition. So the next one we have here is obstructing competition. This is B4. So as I'm going to talk about with B4, B5, B6, what is important here is intent. So with B4, is there some sort of intentional action taken to deceive someone or to obstruct them from competing for employment? When thinking about deception, a case example that I can provide for you concerned a woman who was interested in a promotional opportunity at her agency. She had gone to the hiring manager and wanted to just kind of gather some background information about the position. Well, the hiring manager told her, well, you can't apply for this. You're not qualified. You need to have this specific certification to actually qualify for the position. Well, the woman said, well, there's nothing in the vacancy announcement that said I had to have this certification. Manager said, I know there was a mistake, but you need to have this certification. So she relied on the information provided by the manager and did not apply to that position. Well, the selectee for that promotional opportunity also did not have the certification. And the woman started talking to other folks at the agency and found out that the manager had encouraged other individuals who also lacked the certification to apply for the position. And the hiring manager, through our investigation, we concluded the hiring manager was aware of the fact that the certification was not required to perform the duties of the position. Rather, the manager had provided that information because he did not want that woman to apply for the position. So he told her she could not qualify. He deceived her into believing that she could not qualify, even though she could. So when talking about obstruction, an example I can give you concerns obstruction on a broader scale. A few years ago, I handled a case concerning an agency where there was a unit that had a high rate of attrition. And to address this issue, management and officials decided to issue a blanket moratorium. They sent out this notice to all their employees, informing their employees that they were prohibited for applying for any temporary promotional opportunities, internally and externally. So the complainant filed with our office and provided us with this moratorium notice, given that she was interested in applying for temporary promotional opportunities outside of that unit. Based on a review, we concluded there was a B4 violation there. Managers were intentionally obstructing the ability of these employees within that unit to apply for these opportunities. So we concluded that there was a B4 violation there and asked the agency to rescind that memo and issue a new memo informing employees that they were free to apply.
Ashley, I had a question.
Yes.
What if I give a negative reference for one of the candidates for a position? Is that an obstruction of right to compete?
Sure, thank you for that question. So that would not necessarily be obstruction unless it's an intentionally dishonest reference. So that's what would then push it. Is it intentionally dishonest, or is it an honest assessment, right? So if it's an honest assessment of that candidate's performance or their conduct, then that would not cross into the territory of being obstruction. So if it's intentionally dishonest, yes, that would be a B4 violation there. Also considering there could be possible implications as it relates to retaliation. So I know specifically we're asking a question about B4, but thinking about, if a reference, a negative reference is provided to retaliate against an employee, then that could be an issue as it relates to B8 or B9, which you can learn more about in the presentation that Shireen provides. But as it relates to providing that assessment, if it's an honest assessment, it is not a B4 violation. Okay, let's go ahead and move to the next slide. So we're talking about influencing withdrawal from competition. This is B5. So we generally see this prohibition come up more so when someone has a particular preference, and specifically where we've seen it is with veterans' preference. One of my colleagues handled a case concerning a gentleman who was interested in applying for an opportunity in an agency, and it was open to all U.S. citizens. Based on his point preference, he rose to the top of their certificate of eligible applicants. However, he was blocking a preferred candidate. So the hiring manager reached out, invited him out for lunch, and then told him, you're really not that qualified for this job. You should think about it more if you want to proceed. Also, just to let you know, if I see something that comes along at a later point in time that I think is more well suited to you, I'm more than happy to give you a phone call and give you a heads up on that position. And through our investigation, we concluded that the manager made these representations because he wanted that gentleman to withdraw from competition. He wanted to improve the employment prospects of his preferred candidate, who that gentleman was blocking. So we concluded that there was a B5 violation there and sought corrective and disciplinary action in that case. Let's go to the next slide. And now we're talking about granting an unauthorized preference. And once again, I should go back and say, right, with B5, intent is important. With B6, intent is important. What is the intent behind the action, behind the statements that are made? So when talking about B6, to prove a violation of B6, there has to be evidence that an advantage was provided to someone, and an advantage that one was not entitled to by law, rule, or regulation. The second piece is there has to be intentional and purposeful manipulation of the hiring process. So say, for example, I really want to hire my friend Christina for a position. Christina applies and she doesn't make the cert. So I go to HR, I say, I think I really want to broaden the scope of applicants for this position, or maybe focus on the skill set that I really need for this job. So let's go ahead and cancel this announcement, and I'm just going to rewrite the vacancy or the minimum requirements for the position, and then we'll reissue it again. So I go back and I change the minimum requirements for the position. I know Christina is an attorney, so I write now that you have to have a JD. I also know that she's proficient in Spanish, so I add a Spanish language requirement. And also I know she has experience doing a lot of legal research and writing memos, so I include that in there as well. But I'm including all of that information to target Christina. So I'm intentionally and purposefully manipulating the hiring process to target Christina. Also, I'm providing her an advantage that she is not entitled to by law, rule, or regulation. I'm doing this because she's my friend and I want to hire her for the position. So say I go to HR, I say, okay, here's the new vacancy announcement. And they look at it and they say, no, Ashley, we can't do this. This seems improper. Position. Have I committed a B6 violation? Yes, I still have committed a B6 violation because it was that attempt. It was my intent to grant Christina an unauthorized advantage during the hiring process. And we can go ahead to the next slide. So now we're going to talk about nepotism. I won't spend too much time on this slide. They always say this is the one PPP that most federal employees are aware of. So with nepotism, it is improper to appoint an official. And we're talking about an official. It's someone with personnel action authority. They cannot appoint, employ, promote, advance, or advocate for a relative. And relative is defined here on this slide. I'd always get questions during presentations about, well, who really constitutes a relative? So I made sure when going forward that I would include the full definition of relative on this slide. An important thing to know about nepotism, it works down. It does not work up. So what exactly does that mean? And that is from the case law. So say I go to my boss and I say, hey, boss, I'd like you to hire my well-qualified sister-in-law for the position. She says, sure thing, Ashley, that's fine. That would not be a nepotism violation. If she came to me, though, and said, hey, Ashley, I want you to hire my well-qualified sister-in-law for the position, then that would be a nepotism violation given that hierarchical influence. So that's important to recognize.
I had a question, Ashley. What if I have a friend, maybe it's a former coworker or colleague, and I want to advocate for her for the position. Let's say you're the hiring official and I'm going to advocate, hey, Ashley, I'd really like you to consider my friend who happens to be qualified for the position that you have open.
So generally that would not be an issue given that nepotism strictly concerns a relative. No, a friend doesn't fall into, so long as you're not related to that friend, it would not fall into the definition of being a violation here. You're not advocating for a relative. However, I do want to point out that it is important to be aware of your agency's policies as it relates to nepotism, because some agencies do have policies that do contemplate friends or previous business associates as well. So it's important to be aware of what your agency considers to be a violation of their nepotism policy, because the statute is a floor, it's not a ceiling. So make sure to educate yourself. So the next one we're going to talk about is violating veterans' preference, and that's under B11. So we do not have the authority to seek corrective action in B11 cases. Rather, what folks have to do is file a complaint with the Department of Labor, Veterans Employment Training Services. We do have the ability, though, to seek disciplinary action in these cases. So just to kind of give you a quick example of a potential B11 violation. So say someone applies to a position based on their point preference, they should rise to the top, and their point preference is not respected. So that could be a B11 violation. Or say you have an individual who works for the USDA and they see an internal announcement at the Department of Commerce. And the internal announcement says that folks can apply under the Veterans Employment Opportunities Act, VOA. We'll say that USDA employee applies to that internal announcement at Commerce and their application is not given bona fide consideration, even though they are a VOA applicant. So that failure to provide that bona fide consideration can also constitute a violation of B11. So we go ahead and move to the next slide. So a question for you, which PPP has Jessica committed here? I'll give you a moment to read the question and then I'll go ahead and provide you with the answer. So if you answered B, you would be correct here. So what is Jessica doing? She is granting an authorized preference or advantage to improve the prospects, the employment prospects of Sheila. So there's a B6 violation here. So what does Jessica do? She goes ahead, removes the listing, and she reannounces it because she's trying to block Michael. And now she requires experience in fundraising to help Sheila's application which was ranked slightly lower than Michael's. So there is that preference that's being provided to Sheila that she's not entitled to by law, rule, or regulation. And also there's an intentional manipulation of the hiring process, right? Canceling the vacancy announcement and now including this fundraising experience to target Sheila. So that's why it is a B6 violation. So let's go ahead and move to the next category. So the next category of PPPs that we're going to talk about, and this is the last category of PPPs that we're going to talk about, is potpourri. So potpourri, the reason we came up with this name, it's all of the PPPs that really don't fit so neatly into the other categories. So the first one is coercing political activity, and this is under B3. So what it prohibits is an official from coercing someone to engage in political activity or taking action, about retaliating against someone for refusing to engage in political activity. So a case example that I could provide to you concerning coercion. We handled a matter where a manager, it was performance review time, he sat down with his employee, said, hey, I'm going to give you this great performance bonus, and then added in there, you know, this bonus would be the perfect amount for you to donate to this particular candidate. So that manager was trying to coerce the employee into engaging in political activity by telling her she should donate her bonus to his preferred candidate. So we found a violation there. So the next PPP, and we'll move to the next slide that we're going to talk about, is B12. So we call this the catch-all PPP. The reason we call it the catch-all PPP is because there are a lot of laws, rules, and regulations that can tie back to the merit system principles. So remember those merit system principles, those dues within the federal government? There are a lot of laws, rules, and regs that tie back. For example, there's an OPM regulation that states that employees are supposed to receive an annual performance appraisal, barring some sort of extraordinary circumstance, like say if an agency is undergoing a significant reorg, they don't necessarily have to provide it within that year. But so long as it doesn't fall into that bucket, right? That's not the situation at hand. An agency is required to provide that annual performance appraisal. So failure to provide that appraisal can be a B12 violation. One thing is a violation of the OPM regulation, and then going back to the merit system principles, there are two merit system principles that I could touch upon. One being the fact that employees are supposed to be rated on their performance, right, as part of the performance management measures. And then the second piece, say you have everyone else in the office who has received a performance appraisal except for one employee, and that employee's been there for the whole performance period. So if that employee does not receive their appraisal, they're not being treated fairly and equitably compared to their counterparts. So there are two merit system principles that could come into play there. So that's why it could be a violation of B12. Another example is due process violations. You know, as federal employees, we have certain due process rights. If we were denied those due process rights, it could also be a violation of B12. Let's move to the next prohibition. And we're going to talk about B13. So B13 is important PPP. It's one of the later PPPs, you have 13 and 14. So with B13, what it essentially requires is that if an agency issues any sort of non-disclosure policy, form, agreement, even thinking about an email that's sent out, there has to be a statement in there that informs the employee that any restrictions, any of the agency's restrictions on disclosures are superseded by that employee's statutory whistleblower rights. And we bring it up as it relates to emails, because sometimes a manager may send out an email to, and actually I'll just walk back for a moment, give you a case example. I had a case that I handled concerning a gentleman who had contacted the Office of General Counsel several times at his agency, raising various concerns. So his manager sent an email saying, you are prohibited from having any further communication with the Office of General Counsel. Well, we consider that to be a B13 violation, because what if he is trying to make disclosures? The agency has to have that language in there. More specifically, the manager had to have that B13 language in there, notifying the employee that if he was trying to exercise his statutory whistleblower rights, he could have those communications with OGC. So to cure that issue, we just ask the manager to rescind that initial email and send a new one with that statutorily required B13 language. B13 is also important as it relates to making sure that managers don't make any statements or engage in any sort of behavior that could serve to chill whistleblowing. For example, I had a case where an employee had filed an OSHA complaint. The manager learned about the OSHA complaint and then stood up in an all-hands meeting and said, it is an act of sabotage to file complaints with OSHA. We consider that to be a B13 violation, given that the manager was serving to chill whistleblowing by telling employees that they could not exercise their statutory whistleblower rights.
I had a question, Ashley. What if I have an employee, not you, of course, who is constantly emailing, let's say, the head of the agency, and many of his emails had to do with, what I might think of as sort of minor administrative matters. Maybe a few could be considered whistleblowing, but most of them are not. What could I do about that?
Sure, in a situation like that, it would be appropriate for what the manager could do is send an email to that employer, to the whole unit, maybe, just letting the employees know that for administrative matters, they can go to the manager. The manager can assist them with those issues, but also as part of that to remind employees of their ability, if they are seeking to make disclosures, that they can make disclosures to anyone so long as the disclosure of information wouldn't be prohibited by law or wouldn't be required by executive order to be kept secret, so long as it doesn't fall into one of those categories, right? So it'd be fine for the manager to send an email just reminding folks, for administrative matters, you're more than welcome, please utilize me. You're more than welcome to utilize me as your first line manager. But I do also want to remind you of your statutory whistleblower rights. That way, the manager is providing the processes and notifying their employees of their rights to, seek assistance with the administrative process, but also to make disclosures within the office. Thank you for that question. So the last PPP that we're going to talk about is B14. So B14 is the newest PPP from 2017. And so this PPP really came about because there were complaints coming out of the VA where there are employees who were also patients at the VA. And they were alleging that managers were going into their medical records and using that information to create hostile work environment and to obstruct them from competing for positions. So these employees said, look, these managers are going in, getting this information, and then committing prohibited personnel practices. So this prohibition came about to prevent accessing medical records in furtherance of one of the other PPPs. So it has to tie back to one of the other prohibitions. So how could a manager, most agencies, there isn't just a database that someone could go into and find someone's medical information. So how can most managers potentially have access? Well, think about maybe through the reasonable accommodation process. A manager may have access to an employee's medical information through that process. Or maybe the employee has disclosed medical information to their manager. So if the manager uses that information to commit one of the other 13 prohibited personnel practices, that would be a violation of B14. Well, this takes us to the end, and I just want to thank you for your time and attention today. And always, we at U.S.C serve as a resource. We're here to serve as a resource for you. So if you have any questions, please feel free to contact our office. Thank you.